Hey, good evening, everyone. Let me know if you can see my screen. Hello.
Yeah, it's visible. We can see. At least I can see.
Okay, sure. So thank you, everyone. So this is in line with the continuation, right? The meeting what we had last week, and about the DPDP Act. So I'm not here to say what the organization, right? More from an implementation perspective, it's more from a awareness, knowledge from different concepts, different aspects, the initial details, right? What an individual or an organization should do as well. So I want to talk a little recap, right, about last week what we have done. So mostly we talked about the history of the DPDP Act, the objectives, the definitions, right, with the different concepts: data principal, fiduciary, processor, consent manager, and significant data fiduciary, and where all this DPDP Act is applicable, and what are the features as well, and where it is exempted. So we could cover to a certain extent this much, but there are a few other details what I want to cover in this week. Before that, a quick recap with the history, right? If you know, we already had the IT Act 2000, right, which doesn't cover most of the privacy details as well, and also every nation is coming up with the privacy. So India also thought, okay, let's come up with the Privacy Act. So as part of the privacy, maybe it started in 2017. A committee was formed under Justice B.N. Sri Krishna, and then about different, right, every year the recommendations were submitted, and then it went to the Parliament in December 21, and then it was returned in 2022. So finally, if you look at it in August, right, 2023 last year, the DPDP bill was introduced to the Parliament, and it was passed by the Parliament and signed by the President as well. So if you ask me, the bill is enforced right now. That is more from an history of the DPDP Act as well. And what is the objective of DPDP Act? So we covered to protect the privacy of the individual, to regulate the personal data processing industry, and to protect the digital personal data. So these three are the objectives what we have covered last week. And a few of the definitions, if you look at it, from data principal, data fiduciary, and data processor, consent manager, and significant data fiduciary. So the one which, if you look at it from a data fiduciary perspective, it means any person or an organization, right, who alone in conjunction with any other person determines the purpose and means of processing the data. So the data fiduciary is someone who collects the data from the data principal and determines what they are going to do with the data. And data processor is someone who processes the data on behalf of the data fiduciary. And data principal is one who we as an individual, right, which determines the data, which represents the individual as a whole, right? And if you look at it, the data principal, if it is a child or if it is a person with liability, what it happens. So in India, if you look at a child who is above 18 years, it's considered, but if it is below 18 years, you should have a parent or a lawful guardian giving the consent as well. And for the person with the disability, you should also have a lawful guardian as well. And the other one from a consent manager is the topic what we have covered is means any person, right, registered with the board, who acts as a single point of contact with the board and the data principal. So he basically, the consent manager, he manages, reviews, and withdraw the consent on behalf of the data principal as well. And the last one what we have covered is significant data fiduciary, right? So again, this is still the rules are not out. Okay, who are the significant data fiduciary? This is in line with the data fiduciary, but we have to determine whether the significant is based on the volume, the sensitivity of the data, what it does, or the purpose of the data. So that's still in progress as well. And the next one, what we covered is the applicability of the DPDP Act. So we have had about 13 to 14 features of the DPDPA. So one is from a scope perspective, one is the legitimate users, one is cross-border terrorism, one is child data processing, what are the data breach notifications, the penalties, what they have to do, and what are the exemptions for government agencies, and whatever the data, what is the basics for processing the personal data, and how the personal data are safeguarded and addressed during data breaches. So this is some of the applicability what we have seen last week, and the last one is of course the where this DPDPA is not applicable. So one is the non-digital data. We had quite a discussion about what happens in paper and form, which is really right now not only from a physical but also from a legacy perspective. We discussed in detail that as well. So as a whole, if you look at it, what are the exceptions for the data, non-digital data, and the data managed for personal or household purposes, and data made openly accessible by the data principal or any other entity due to legal obligations. So these are all the topics what we have covered last week. So I'll make a pause here from a recap perspective to ensure, right, that we are in line, and if there is any question, I would like to take it before continuing for this week. This is more a recap, but of course the deck will be shared with you after this session, and then of course you can connect maybe with GCA or me from a clarification perspective.
And I think it'll be relevant for anybody who's kind of joined today for the first time and didn't attend the last session. If there's any question, we can take it right away. Otherwise, we'll just move. So any hand raise? I think none. So, okay, there is a hand raise. Ashutosh, please go ahead, unmute yourself. Ashutosh, please unmute.
Yeah. Hi. Hello, everyone. See, my question is that in case of breach, data breach, like employee data breach, since we are outsourcing payrolls, is it mandatory to immediately report to the board or sir? And also, do we have to take care of the client's data also, customers' data?
See, one is from a breach. So there are two questions which are said from a certain. Yes, certain you have to report it. And from a DP data protection board which is being formed. So it's if you ask me, certain you have to report it. From a DPB perspective, right? It's the rules are not out. So it's not reported to DPB right now, but of course to the certain 72 hours. And any breach, right, if you look at it from employees or any customers, but of course you have to inform the customers as well. When you report from a breach to the certain, you also have to report the customers from a breach perspective.
Okay. But like, we have customers like big organizations. So how to take consent from them, like a government organization, like we are working on some government construction projects. So do we have to go to the relevant department, ministry, or how?
No, so what you're saying is, so you're working with the customers for all the government projects, and you have to get consent from them, right? So see, it can be, it is from an organization, or is it from the individuals. If it is more, see, I don't know, from a contract perspective, you would have covered that as well, right? Or from when you sign an agreement or a contract, how the data is being processed.
Okay.
So is that being covered as well? Because if you compare from a GDPR perspective as well, if you have a contract and if the data, if you are clear and open how the data is being collected, processed, okay, that is something which you have to inform the data principal.
Okay. Thanks. Got it.
I would like to add, Ravi, I think what Ashutosh was meaning to ask was that in case of a breach, of course, you've clarified that he has to report to the certain and to the data protection board because it's not out yet in terms of the process and the SOP. We still have to only report to certain from a regulatory point of view. But when it comes to the customers or the stakeholders, if you will, which could be employees or customers or suppliers, if you're taking their data and you're processing it in a certain way, that of course is a part of the contract, as you say. But if there's a breach, yes, the customers must be informed through an email, through any kind of communication which happens between the customers or stakeholders and the company. Is that a mandatory conversation for a communication that must happen? I think that is the question.
It's a mandatory, yes.
Okay. So Ashutosh, is that what you were looking at?
Yes. Thanks a lot.
All right. Thank you so much.
Sure. Sorry. So, okay. Now today, right, I just want to cover some of the details on what the data principles, what is the data fiduciary, what are the duties, right? Sorry for the background noise. So data principles, right? What is the rights of a data principal? Data fiduciary, what are the obligations from a data fiduciary perspective? So if you look at it, what is data principal? An individual whose data is being processed, right? So me as an individual will have the right to obtain information about processing. So if someone, so there are, for example, right, if you go to the bank, there is a big form which they give, and at the end of it they say I agree. And if you look at it, nobody reads what is that, because in the interest of time and other perspective, if we just say okay, I agree and sign it, so we don't know why it is being processed. And also seek correction and erasure of personal data. So we have given in multiple places. This is a process which has to come in place, right? So I can ask for the correction and I can ask for the erasure of the personal data, or nominate another person to exercise rights in the event of my death or incapacity in mind, if I'm not from a disability perspective as well, and any grievance redressal. And also, if you look at it from a data principal perspective, the data principal also has some duties which he can do. He can't impersonate any other person or suppress any material information while applying for any document, unified identifier, or proof of identity. Because I'll give an example for this, right? There is a recently in paper as well, right? So what some of the tenants are doing is, or anyone, right, they're using fake PAN card or for HRA purpose. So maybe mine is used somewhere else. So someone is using my PAN card for rent exception, HRA benefits. So these kind of things which we should not do it as well. And don't register a false or frivolous grievance or complaint with your data fiduciary or the board. So me as an individual, if you look at it now, everyone is going for the case, right? So I'm just saying from a civil case perspective, say here it won't be like that, but at least don't just put a grievance on any organization or data fiduciary saying, okay, they have not processed the data in a fair, transparent manner. So that is something as a data principle we have the right and also certain duties to do from a data principle perspective. So next one is data fiduciaries, right? What are data fiduciaries? They are the one who collects the data and process it for some purpose, but that purpose is something with the data fiduciary has to tell to the data principal, and it has to be compliance with the DPDP Act. Of course, the rules, everything when it comes out, it will be very clear what the data fiduciaries do with the data, what they are collecting and processing the data for. And also, right, the data fiduciaries also should ensure that the data should be deleted, right? If the data principal withdraws the consent or it is no longer needed. So 10 years back, someone has collected my data and it is still being used for processing, but if it is not needed to be there, that has to be addressed. But now the question comes, okay, India as a nation with too much population, is this, and too many entities where the data are there, is it possible? So that's the debate which we had as well. It's going to take time, but the coverage 100%, it's still a question mark how long it is going to take. So I want to talk a little bit on the significant data fiduciaries. So how you term a data fiduciary as significant data fiduciaries. So the central government, right, if you look at it, they have the authority, right, to identify specific data fiduciaries. On what basis? There are some important factors the government is deciding. It's deciding. It has not decided. It's still deciding, which includes the volume and sensitivity of the personal data processed, or risk to the rights of the data principal, or the potential impact on the sovereignty and integrity of data, or the risk to electoral democracy, or the security of the state and public order. So it's all in that debate as well, but nothing has been finalized. So now, who is going to determine, and when me as an organization will know whether I am a data fiduciary or a significant data fiduciary? Maybe sometime in July, August, it should be out with the rules which is in process right now. And if you look at it, right, if you are determined as a significant data fiduciary, you should appoint a data protection officer, DPO, he should be based in India, and you should appoint an independent data auditor to evaluate the compliance by the significant data fiduciary, and you should undertake a data protection impact assessment, DPIA, and undertake periodic compliance audit. Now the question comes, okay, if me as a significant data fiduciary only should do this? No, all data fiduciaries as part of the best practices should have all this, but this is mandatory from a significant data fiduciary. But it is always too good to have auditor assessing and do compliance audits in your environment, which will be really helpful from a compliance perspective. So the DPO is something which every organization, if you look at it in the recent past, in the last 6 months, you would see a lot of opportunities coming from a DPO. And again, the question comes, okay, whether the CISO can be a DPO. That's the another debate. So I'm not going into that. But the DPO is going to be there in all or many organizations in the next 6 months. So any questions till now before I get into what is data audit, data impact assessment, and DPO does? So I assume there is no questions. So I'll get into some of the cons. Yeah.
See, as you said that there is a debate going on, like whether CISO can be a DPO, because I'm also playing a group CISO role. So there is a requirement from the management, or they suggest that you only be a CISO, DPO, sorry. So I already said that it's a conflict, because since CISO has a technical control, he can hide if there is a data breach. So they won't be able to understand when DPO, when the breach was happening. And one question I want to have, that can DPO do the audits also internal, just like for the compliance?
So it's a DPO more, I would say, oversee the audit instead of he doing the audit.
Okay.
And DPO, so where should the DPO report to is another debate which is going on, whether to the board or whether to the executive, any of the executives as well. There is another debate which is going on.
Or might be a risk management team, risk management, enterprise risk management. It's like a
Which one? A DPO reporting to a
Yes.
enterprise risk management, like
Yeah.
ERM or CRO.
Yes. Yeah.
See, that again, it's again debatable, because they say DPO as the legal thing or a compliance thing, so he should be aligned with that. But when say CRO, it's if you look at it in the as a whole, right? There are hardly less than 5% of the DPO across the globe is reporting to the CRO.
Okay. Got it. Thank you.
But I would say the DPO, CISO and the DPO conflict should be different. See, again, CISO should report to CIO or something, right? CIO, there is always a conflict. But CIO and CISO should align, collaborate together. That's the best thing. A CISO reporting to the CIO is always going to have a failure. And as I said, the DPO reporting to the board is ideal, but in many cases, it is not. In India, it is not possible because of the hierarchy of what we have.
Okay. Thanks.
Ashutosh, did you get a chance to attend our organizational structure session about 4 weeks ago? Were you there?
No. Sorry.
Okay, fine. So what we'll do is we'll share that. So we are gonna have a section on the website where we actually upload all the resources which were used in all the expert sessions. So if you were to refer to that organizational structure, you'd have answer to all your questions.
Okay, sure.
All right.
Thank you very much.
Please carry on, brother.
Yeah, sure. Thanks, Harshit. So anything we can discuss offline as well, Harshit?
Yeah, definitely. Sure.
Yeah,
that will be good.
Sure. I'll share my details as well. So now data audits, data impact assessment, and data protection officer. So it's all applicable from a significant data fiduciary perspective, as he has to fulfill these requirements, right? And the auditor role, with who is assessing the significant data fiduciary compliance, right? It has to be outlined in the act. So it's the rules. See, again, the question is from a GDPR perspective and DPDP, there's a lot of variance, but from a DPDP Act perspective, the rules are getting laid out. And the one thing about the data fiduciary, significant data fiduciary, is you should do a DPIA, which is data protection impact assessment, on a regular basis, and which should involve the description, the scope, the purpose. When I say scope, purpose is one and the same. The assessment of harm, the measures for managing risk of harm, and such other matters, right? With respect to processing of personal data, it should, when I do an assessment of data, it should cover all this aspect. The report should cover these details, and undertake every time the regular audits and implement any other measures that align with the provision of the Act. So Data audit is one, DPIA is one. So it's all you have to continuously do. And if you look at it, right, assessment involves detailing the rights of data principals and the intended purpose of processing their personal data, evaluating and managing the risk to these data principal rights, and addressing other pertinent aspects of this process as per the prescribed guidelines. That's the purpose of the DPO. So, or DPO who oversees the DPIA in doing the assessment as well. So, as I earlier said, the significant data fiduciary is responsible to appoint a DPO. The DPO will serve several roles, right? The one of the important role is that the DPO will act as the representative of significant data fiduciary, which me as an organization, I will have a DPO who will be the single point of contact with the data protection board and the data principal as well. And that's the second line which I have covered, is an individual accountable to the board of directors or a similar governing body of the significant data fiduciary. He will also as a designated point of contact for the grievance redressal mechanism specified with the act with the data principal. So the DPO, so Ashutosh, to answer your question, it's going to be the critical role who is going to work with the internal board, with the data protection board, and also a single point of contact with the data principal.
Yeah, sure. Thank you.
And before I move, right, the next things, because there's a lot of things which are happening in the industry as well, right? As a lot of e-commerce, everything increases, right? That's a lot of issues a lot of risk issues coming up in the privacy space as well. When I say personalization, see, right? When I do shopping, I want something which is which basically gives me the view, right? What I really want based on my history, what I have browsed, and other things as well. So if you look at it from a perspective, right, the balancing personalization and privacy, the one thing, right, the striking a balance between personalization and user privacy, the consent management poses another hurdle, because as obtaining explicit consent, right, while making user friendly and adhering to the rules can be intricate. So I'll give an example. So me as an individual, right, data principal, I want something user friendly which collects some of the data. So I can share these details, but the problem is it is also from a privacy perspective. I want to ensure that it is the data which has been collected, it's used for the processing for what it has collected, because it should not be used for any other customers of similar interest as well. And if you look at it, because of this personalization, when you make user friendly, right, there's a lot of increase in the technology, legal support, and compliance team. So as an organization, suppose e-commerce, mostly in the retail sector, if you look at it, right, you have to come up with something. It's more, I forgot the term. It's more in line with the demands, right, for the users. Is people demands what is that in the market, right? So it's all what happens is many retail brands collect some of the data as well. You have to ensure what data you're collecting for the personalization, user friendly things as well, and how it is being processed. But of course, from the DPDPA, when it comes in, it becomes a very compliance based for the organizations in what they're collecting from the data, even though they give user friendly and personalized maybe products, pages, or maybe from a shopping perspective, what the user wants. So this is in line with what I've earlier covered, right, from visualization perspective, right? So, I don't want to just reiterate what I have told. It's more the platform, user-friendly platform is going to cause a concern from a data privacy perspective. So before I move the next one, right, next 2-3 slides, which is very critical from the knowledge perspective, right? One is from a CISO, one is from a GDPR and DPDPA, and the last one is how organization can look in adapting the DPDPA Act. So any questions till now before I move into these 3 key topics?
Let's continue, Ravi. I think we have to kind of spend some time on this, and we are already anyway at 4:35. So if there are no questions till now, let's just continue.
Okay. So I've just listed some 5 fast tracks for CISOs, right, on DPDP Act. One is from a penalty for misuse of data. So now this comes in because not all organization is going to have a DPO. So the CISOs, right, the facts, what they have to consider, the penalties for misuse of data, what are the principles of data collection, what are the languages they are using from an accessibility perspective, what is the alternative dispute resolution, and the RTI, harmonization of RTI and data protection. So penalty for misuse of data. So now if you look at it, right, the bill proposes a penalty of starting from INR 10,000 to INR 250 crores on entities for misusing or failing to protect the digital data of individuals. So the CISOs must ensure, right, strict data protection measures to avoid FT penalty. When I say data protection, it includes your data security, security controls, right, from classification to DLP to your labeling and other perspective as well. And principles of data collection, the bill emphasizes principles like legality, the purpose limitation, data minimization, and storage limitation. So the CISO should ensure that data is collected lawfully, used for its intended purpose, and kept to a minimum. The language accessibility, the notice and consent will be provided in all the 22 languages mentioned in the 8th schedule of the DPDP Act, making it easier for people to understand their data rights. And CISOs, right, from a language perspective, they should ensure transparency and clear communication with users regarding data handling. And alternate dispute resolution, the bill establishes an alternative dispute resolution mechanism through a data protection board, allowing organizations to rectify mistakes and pay penalties for data breaches. So I make mistakes, I report to the board, I pay the fine, I rectify it so that in future I'm protected as well. And my last one is harmonization for RTI and data protection. The bill harmonizes the right to information provision with personal data protection, indicating the need for a balance between transparency and data privacy. So this is something the CISO, right, from an organization perspective, from protecting from data to collecting the data breaches, including why they are collecting the data, and also rectify and correct the data what they have. So if you have a DPO in the organization, yes, it's well and good, but not all organizations are going to be significant data fiduciaries to have a DPO in place.
Hey, Ravi, I have a question.
Yeah.
Regarding the languages where we are said that the notice should be in 22 languages, which are there in the 8th schedule. When we look at the act, the language in the act is mentioned as either English or languages mentioned in the 8th schedule. So does that means either it has to be English or any other language in out of those 22 languages, or it has to be in English and plus all those 22 languages?
It has to be in English and one of the 22 languages.
But the language in the, when I look at the statement, it has a or. It doesn't have and.
Okay. Oh, maybe I overlooked. Sorry. Okay.
So actually, that is the confusion I always have whenever I read that that act again and again. It has a word or.
See, why I said right in English and the language, right, local language to the states in the in the states, right, because there will be native plus people from other states, right, who doesn't know the local language. If suppose someone is looking right in Bangalore, right, Kannada and English.
No, absolutely, that's true. That's a general understanding that there would be people who may or may not understand English or maybe any other language. But the act itself has been worded in such a way that it says English or. So maybe.
Okay, I'll discuss with the person, right, whom I know, and check with them as well. And
sure,
also
great. As a follow-up response, that will help.
If possible, maybe I'll ask them to correct that as well, English, or maybe from a law perspective, it's just a give a recommendation, but we will see that. I'll do that.
Sure, Ravi. Thank you.
But based on the discussions what I had with some of the team or people, it has to be in English and one of the 22 languages, but I'll get it clarified and confirmed to you. So now, if you look at it, right, so GDPR, which came in 2018, and DPDP, which is coming after 6 years, right? There are a lot of, many people said DPDP is Indian version of the GDPR, because we also want it is just a copy and paste. No, but there are a lot of variations in what they have come up with, because I have just put like 9 to 10 categories, right, where this GDPR and Indian DPDP Act varies as well. From a data categorization, in India, we know, right, it applies to all personal data. There is no category of data like confidential, sensitive, like almost like PII and PHI perspective. So it applies to all personal data, but in GDPR, it's recognized special categories of data such as racial, ethnic, political, biometric, etc. It's being used. The ground for processing, it's consent-centric, legitimate interest limited. It's a broader legitimate interest for processing as well. The type of actors we discussed: data fiduciaries, significant data fiduciaries, processors, etc. In GDPR, there is only 2: data controllers and data processor as well. And children's data, in India, we have age of consent is 18, and in GDPR it is 13 to 16. It's ideally 16. And retention timelines, the rules to prescribe specific timelines for data retention is not there, and that's the rules which is coming in place. And in GDPR, the controllers determine the retention period, right, subject to justification. And in some of the European countries, we have even the country determines the data retention period as well. And breach notification, all data breaches has to be reported to the Data Protection Board and data principal, because this is one of the questions which came earlier, and rules to be prescribed as well. And in GDPR, it's a risk-based breach reporting. Only high-risk breaches to be reported to data subject. And cross-border flows. And in India, you can transfer data to any country except blacklisted countries by the central government. So you are allowed to move data anywhere. In GDPR, it is permitted through adequacy decisions. That's one thing which you have to look at it. And consent managers, right? So new institutional mechanism for consent management must be registered with the DP board, and there is no consent managers in GDPR as well.
So
this is
one quick question.
Yeah.
Sorry, I might have a lot of background noise right there, but one very quick question is that how do we handle foreigners' data as per the requirement which will be hosted with a hosted infrastructure in India? Does this particular DPDP Act covers interest of a consumer who is a foreign national?
No, this is only prescribed to Indian data, Indians data.
No, do you mean to say it only is prescribed for the Indian residents, right?
Yeah. Yes.
So how do we go ahead and take care of the foreign nationals if they are coming here for a long stay of 2 years, 1 year, 2 years, 3 years, and the data into the system? How do we go ahead and protect their interests?
See, as per my knowledge, there is nothing from that perspective is being considered, but I will check and come back on that.
I mean, in today's scenario, if it doesn't fall under any regulation, would it not continue the same, Raviji?
Yeah, correct. So right, what you're saying is correct. That's why I said so. Right now, it is not. We are not doing it, right? See, for example,
So there is
any
one
data-
very clear question out here. So the question regarding the residency status is there, whether this act defines the for any particular
I lost you. It's breaking.
non-Indian. My question was on top of the data itself. So DPDP does it cover the specific residency status clause? When a person is an Indian citizen and or maybe a special resident status what they have got, does it cover that as part of the data what is used for those particular individuals and how their interests will work?
So it was breaking, but I don't know if anyone would have heard. But what I heard is, if the Data Act covers whether the residents, the permanent residents, or the residents for some time in India. That's what your question is.
Yes, absolutely. Bang on. So is there which covers the interest of special residency status or any particular residential status as part of the Indian Citizenship Act or any particular act, whatever you talk about, from the residential status in India and its effect with DPD?
See, as per my knowledge and what it has written in the Act is Indian residents, right? When I say Indian residents, who are Indians, which I assume by Indians by citizens. That's what I mean.
Well, residency status and citizenship are two very different things all across the world, if I'm not wrong. Sorry, I have a lot of background noise out here. Probably I'll just take 2 minutes to go separately and then go ahead and discuss on this. You can continue until.
Yeah, you can. Sure. So now, when we look at the penalties, right, there is a different kinds of penalties what the DPDP Act bill has come up with. Where if there is a personal data breach, there is a fine up to 250 crores. Again, it depends on the rules which is being done, right? What kind of data, what is the impact and other things. And from a failure to notify breach, it's up to 200 crores. And breach of any additional obligations, children or significant data fiduciaries, That's a penalty up to 150 crores. And anything, right? If breach of duties under section 16, of course, section 16 is quite huge. There's a fine up to rupees 10,000 rupees. And anything from a breach of voluntary undertaking, there is a penalties corresponding to the relevant breach. And any other breaches, they have set up to 50 crores. So again, the rules may come in place, but if you look at it, it starts from 10,000 rupees from the basic to all the way up to 250 crores. So again, compared to GDPR, the fine what we have here, it's of course, if you look at it like 30 million, right? USD is the max in India. If you look at it, it starts with 150 all the way to 30 million. So this is my important slide, right? From an organizational strategy perspective, how we have to ensure from a compliance to DPDPA. There are 10 key things which I have put, which I feel will be very important for any organizations. One is establishing a privacy governance framework, appoint a data protection officer, and implement privacy by design and default, conduct data protection impact assessments at least, if not at least once in 6 months, and develop internal policies and procedures from a privacy perspective, conduct trainings and awareness programs, establish vendor management procedures, and of course monitor and respond to regulatory developments whenever, because the DPO is going to be the point of contact with the data protection board. So he will know what all the changes happening from a regulatory perspective, conduct regular audits and assessment, and establish incident response and data breach management. So this 10 key things, right, will help any organization to be compliant to DPDPA. That's in a nutshell. So I'm going to give a summary, right, what we have done so far, right? So the DPDP applies uniformly to all digital personal data, irrespective of sensitivity. It describes the consensual or non-consensual grounds for processing personal data. It specifies the obligation for data fiduciaries. Of course, it is called data controllers in European Union. It designates certain data fiduciaries as significant data fiduciaries with additional obligations. The rules are coming out. It sets out the right of data principles. They are called as data subjects in EU with their duties. The DPDP Act permits cross-border data flows, but allows the government to restrict data transfer to certain geographies which are blacklisted by the central government. It levies penalties up to INR 250 crore for various significant contraventions. And at last, it established a data protection board to regulate and enforce DPDP Act provisions with appeals lying before the Telecom Dispute Settlement and Appellate Tribunal. So this is something DPDP board, right? So they are working with the different agencies to form the rules and provisions. So that's in a nutshell from a DPDP Act perspective. There are quite current trends and next steps, right? From a metrics perspective, about 50% of the organizations are yet to acquire the required skill set to implement the DPDP Act. I know it's still 2023 December, but of course in the last 2, 3, 4 months, it may be changed, but it is still 50%. And only 36% of organizations have DPO. And now when I say 36%, now it's all, it determines, if you determine significant data fiduciary is 50%, 60%, then 60% should have the DPO. The other challenges identified include inadequate awareness of regulatory guidelines, resource constraint in their compliance journey, and organizational resistance to change. So, of course, organizations, if you bring in any new things, it's always a resistance to change. And Section 14 of the DPDP Act provides a right to nominate another individual in case of a death or incapacity of a data principal. So that's something which I want to say and close with the current trends. But going by this, once the rules comes out in June, July, this 50% will become 60, maybe 70, or the 36% may move to 46, 50. But the DPO role is a senior leadership role, and it is going to be quite demanding in the next few months to come. So that's something which I would say CISOs and DPOs are going to be in demand in the next 6 months to 1 year. Thank you. So this is something that data concept, so I don't want to get into that. This is more from an appendix perspective. So any questions?
I think we are fine. Thank you.
I have a point to make. I was looking at the chat. Yeah, thank you. Absolutely. No, I'm going to thank you at the end, Ravi, but I was going to just refer to a point before the discussions come to an end, made by Ajit in the chat. He has pasted some text which talks about the application of the act, and Jawahar was asking a question with regards to who does it apply it to. So there's a statement A which says application of act apply to the, so the act applies to the processing of digital personal data within the territory of India where the personal data is collected. So is it somewhere else that the act says that the personal data should belong to an Indian citizen? Because if it is about the location, then anybody even residing in India, whether or not, at a permanent status or a visa, any visa status, if it's collected in India, the act is applicable. So is there a comment on that?
This is a very important part which you actually explained out here. Again, I will rephrase this once again or add to it my 2 cents, that how does it bring up a very dangerous situation against us, because we are fighting today. India is an innovation hub. We are fighting against multiple startups all across the world. The amount of money which is being put into those startups out there, probably the similar or almost similar kind of ideas will sprung up everywhere all around the world, right? So it could happen in this way that we might go ahead and get that some company or a startup company can become bankrupt with this particular kind of a fine which can be levied on them, with the amount of firepower in terms of financial firepower available with those startups, and they can go ahead and break down the Indian company. So this can be used in a negative way also. That is why I was very specific about asking on the residential status. How does it actually go ahead and affect? If it is only for the Indian citizens, if we are processing it out here for the Indian citizens or a foreign resident, how will it ultimately impact us? Because this can go to the International Court of Law also.
Right. So Ajit, do you have a point to make on this one? Because you pasted it, so I'm imagining you may have a comment to make on this one. Ajit?
Yeah, Rupali. So strictly, I think if you go by the text, the verbalise of what is there in the act, I think I agree with what you said. The residential status would not matter. It is really the data that is collected within the territory of India that makes the difference. But see, like everything, it all depends on how the implementation of the act comes out and what laws and procedures are mentioned for better clarification on this.
Yeah, thank you so much. I think the rules are yet to be out, but I think because Ravi was kind of sure that it applies to Indian citizens, I'm sure it's someplace else where the Indian citizens as a term is also mentioned, and there is a conflict within the act itself. So Ravi, I think let's just do some bit of going deep diving into this particular question of Jawahar, and we then share the clarification with all our members through email on this particular open point, so to say. And other than that, I think we're all in.
Yeah, see, if you look at it from a GDPR perspective, Jawahar or Ajay, it applies to them, right, from an EU citizens, whether they are in Europe or outside Europe. So, if me as a citizen go there, whether the GDPR applicability becomes, it's not, right? So, but being said that, I will get the details. So this is something, the 3 points which I discussed last week as well, right? Which is from the data perspective, which is collected in the territory of India, but whether it applies to all residents or from any classification is there, we'll come back on that.
Great. Thank you so much. I think we are dot and at 5 p.m. and we are good. We've already kind of asked questions during the session, so I'm assuming there wouldn't be any other question. But in case there is, a hand raise is welcome. Else we'll end the session, and you would in your email.
One question. So one question, Nishi, you have asked, right, from an educational institution. Yes, it is. It will be included. Educational institutions as well from a privacy perspective, because they are going to collect children's and students' data.
Roman, I was just thinking, have you been in touch with any of these big universities or educational institutions which basically offer courses from KG to PG, right? There are many across India. What kind of a readiness have they done? Of course, we have many people here in this forum who have got kids, school-going kids or college-going kids. So how exactly are they making arrangements for that?
So Nisha, I will tell you one where I have been talking to some colleges as well. So they are not ready from a cyber security perspective as itself. So from a data privacy, many of the colleges are not still ready. But now, if the law becomes, how far or how long they have to become compliant is something which we don't know. Whether it's 1 year, 2 years, we don't know. So now everyone is waiting for the rules to be out to ensure, okay, by when I should be compliant. Because when GDPR was rolled out, right, in 2016, they said by May 2018, you should all be compliant from a GDPR perspective. So in that case, whether DPDPA if comes and says, okay, by 2026 or maybe 2027, you all should be compliant. So that is something going to determine the urgency for educational institutions to take it fast.
Okay.
Yeah, currently I absolutely agree with Ravi. I was at an institution yesterday, an institution with thousands of students, and readiness is absolutely going to be a journey. I would say, they're intending to be on, but trust me, there's a lot of work that is required, and people are kind of waiting for the rules to be out. Yeah, it's going to be a while. Absolutely. So that's it. I think. Thank you so much, Ravi, and thanks everyone. We'd look forward to more such engaging sessions, and the interactions make the session successful. So thank you so much for participating, all of you, and have a wonderful weekend ahead. Ashutosh has a hand raise. Sorry, Ashutosh, you already did a hand raise, and I forgot to kind of take your question. Please go ahead.
Rupali, can you share me the previous day's recording?
Yeah. So what we're going to do is we're gonna share a link. Sorry, we didn't do it last time because we thought it would be difficult, to be sent as a document in everybody's inbox, but that's going to be heavy. So what we're doing is we're creating a resource page on the GCA website where you can download the presentations and also access the video. All right. So give it until the beginning of the next week, and you'll have it.
Sure. Yeah.
Thank you so much, Rupali.
Thank you so much, Prasad. Thanks everyone.
Thank you.
Thank you.
Thanks, Parth. Have a good weekend.
Thank you.
Thank you, same to you.